we are interpreting this letter as a suggestion of
They are not
the
going.
direction.
They are writing this.
Yes,
No way in which
yes. But you see, for
they will
purposes,
say they are properly.
for purposes of escalation, we will just say that, well, in the meantime, we shall leave proceedings. These are fundamental questions.
Get
We are
instructions
appealing.
whether to appeal.
Yeah,
At least get instructions.
yes, we need to get instructions on whether or not we are going to appeal against this matter.
Yes.
Yeah. And it,
We must not be pushed into
yeah, and of course now after this, you see me, I would actually be surprised why anyone now a case, because there are specific cases for refusal, and we say after this we did. So that is really where the matters go. Yeah.
And actually, in your budget,
Yeah.
015,
Yeah.
there's a formal
Complaint. Yeah. Oh, there is a yeah. Yeah.
this content be had by the people.
Yeah.
So that if they say they are properly empaneled,
Yeah.
they will not refuse themselves.
Yeah.
There's a first thing that should be heard.
It's contempt against
The Senate, the National Assembly.
that. Could have come from 15 was
It's 14.
it's one.
It's 1-4.
Now is in 1-4.
It's not. I dealt with
Have you seen
I dealt with it in where?
1-4?
It is there.
By parliament.
Yeah,
That is failed to do what?
that is failed to comply with the orders regarding public administration.
Oh,
The judge direct
yeah,
right.
yeah,
Those of the agents in this matter.
yeah.
Let this be had.
You, excuse you, my Lord. My name is Shadrach Moses, the Solicitor General. Hearing together Professor Milimani, Senior Counsel for the Attorney General, Emmanuel Peter, Deputy Chief State Counsel, Charles Mutinga, Deputy Chief State Counsel. Then for the National Assembly, we have El Lumbo, here for the National Assembly, and Paul Amoni, and the Honorable George Tonga lords and my lady, for the Speaker of the National Assembly, we have Elson Milimo and Josephat Milimani appearing for the Speaker of the National Assembly. My lords and my lady, for the Senate, we have Professor Tom Ochenda and Moni Mukele Edwin. For the Speaker of the Senate, my lord, my lady, we have Mercy Tanchi and Peter Wanyama here for the Senate, for the Speaker of the Senate. And for interested parties, my lord, we have Moses Oge, we have Dr. Mutomi Tiokoro, we have Kenny Meli, we have Conference Weleru, and Eric Murioki appearing for Professor Kitule Kindiki. Sorry, my lord, for the Senate, we have Kirali, Honorable Kirali Sigay for the Senate. Yes, that's an addition about Professor Thomas Sigay. Honorable Kirali Sigay, Senate. My lord, for the sixth respondent, much obliged, my lord. I leave it at that.
And my lords and my lady, my name is Ibe Mungai. My colleagues are Mr. Muge for the and Mr. Ndegwa in petition number Kirinyaga.
I appear with Mr. Swanya, George the Kimpa, and Tom Macharia for the Deputy President of the Republic of Kenya in the consolidated petition and any other petition where he is.
My name is I appear for my young friend. Don't I haven't seen and I also appear for myself.
No, my lady and my lords, for the third petition. May it please you, my lady and my lords. My name is Nelson Hagu. I appear for the interested party.
This afternoon, and I believe my learned friend will address it. We were served with a notice from the office of the deputy registrar, indicating that there were several matters that were to be mentioned before you this morning, this afternoon, and last evening when you were breaking, we were to come for a ruling. Perhaps we need to have clarity that we may not have a mixture of things. Then if that's the case, therefore, then it means there are some advocates who have gotten on record for quorum who did not participate or they are not parties in this particular proceeding.
Lord, lady, we have asked that will deal with his friends and then definitely there is no harm in I appearing.
want to address it. Yeah. Whom we refer to here in power of assigning and empanelling such internet between that score look at how the court points but for its own theory that is for whereas score is what is the field of rights values right and based on human dignity, equity, freedom, and upward and object among scores values, advances, human rights, and development, and contribute good governance. Failing the courts have over time in the case of David Lee and others judges dealt with four constitutional interpretive principles, being that the constitution must be interpreted holistically, that the constitution does not favor formalistic approaches to its interpretation and must not be interpreted as one would and yes, has provided its own theory of interpretation, protect and preserve its values, objects and purposes, and that in interpreting the constitution, non-legal considerations are important to give its true meaning and value. In court, in the matter of the Kenya National Commission on Human Rights, Supreme Court advisory opinion reference which I've given, paragraph 26, answered the question as to what holistic interpretation of the constitution means. As follows. What is meant by holistic interpretation must mean interpreting the constitution. It is contextual analysis of the constitutional provision, reading it alongside and extends other provisions so as to maintain a rational expression of what the constitution means in the light of the history of the issues in dispute varying circumstances. The case of Tani Fuza Basa, Attorney General, which I've given citation, I've given the court was of the firm position that the constitution must be read as an interpreted code. The court observed as follows. The entire constitution has to be read as an interpreted code. No one particular provision other than this is the rule of harmony, the rule of completeness and positiveness, and the rule of paramount of written. But the tenet that the constitution does not favor formalistic interpretation, and that it must not be interpreted as one would and yes, the court pronounced itself in the case in the interim independent election commission. The court said as follows: the rules of interpretation do not favor formalistic or positivistic approaches. The constitution has incorporated non-legal considerations, which we must take into account in exercising our jurisdiction. The constitution has a most modern bill of rights that envisions a human rights based values and principles and created in the top preamble in Article 10 in Chapter 8 in the various provisions reflect historical, economic, social, cultural, and political realities that are critical in building a robust, effective, indigenous, and authority must be reflected in expounding the principle that the Constitution has provided its own theory of its values, objects, and purposes. Retired Chief Justice, His Lordship Honorable Mutunga, had the following to say in his concurring opinion in the Speaker of the Senate and another Honorable Chief Justice then had this to say. In both my respective dissenting and concurring opinions, the matter of principle of gender representation in the Senate, I argue that both the Constitution itself and the Court Act both provide comprehensive interpretation upon which fundamental truths, pillars, and sovereignty in both opinions, I provided the interpretation of holiness as we identified before. More which I have. The court also expounded the incorporation of non-legal consideration, the importance in the Constitution, the inclusion of Kenya and five others, all with the paragraph 6. We this is once again considering of Constitution, human rights, Bill of Rights, fundamental rights in question. In this case, freedom and independence of the member. Second is opportunity how historical, economic, social, content, fundamental principle, standing with gender, that pronounced on its theory of the brief narrative of historical, economic, social, cultural, and political backgrounds has been given above in paragraph 145. We begin with the concurring opinion of CJ in Procedural where there was reference to capital, where it was said that differences in capital will not therefore always be enough. Different cases have to take into account these peculiar Kenyan needs and context. Set out the individual story of the story is derived from the Constitution group conception that my dissentee carry opinions ignored as examples of effective holiness. In the case of Center for Rights Awareness and another, the Court of Appeal also dealt with the subject of laid out the very principles discussed. The Court further recounted the nexus between the principles of safety, principles on constitutional interpretation, they also apply to the construction. There are other important principles apply. Also apply to the construction, such as presumption against absurdity, meaning that a court should avoid a construction that produces an absurd result. Presumption against unworkable or impracticable result, meaning that a court should find against a construction which produces unworkable or impracticable result. Presumption against non-malicious or illogical result, meaning that court should find against a construction that normally or otherwise produces an irrational or illogical result. Presumption against artificial result, meaning that a court should find against a principle that the law should serve public interest, meaning that the court should strive to avoid adopting a which is in any way adverse to public economic, social, and political or other. Court, as an independent arbiter of the state, and has to be guided by the letter. On our part, we wish to emphasize that the Constitution directs that it shall be interpreted in line with the doctrine. Doctrine holds that a document meant to evolve over time to reflect societal changes, contemporary realities. Further recognizes that the law is dynamic and adaptable to evolving circumstances, often encapsulated in the maxim that in quote, the law is always. It underscores the constitutional provisions as not static or frozen in time, but must be understood as applying to current circumstances, regardless of their origin. This interpretive approach ensures that the Constitution remains relevant and effective in guiding the governance and legal framework of a modern dynamic society. However, the doctrine that the law is always speaking aligns with the approach as endorsed by courts in various jurisdictions. Under this approach, courts are required to interpret constitutional provisions in a way that gives effect to their underlying purpose and objective, rather than adhering to a rigid or literal reading. Further, courts have emphasized the need for a flexible and forward-looking interpretation to meet the needs of modern states. With above interpretive principles in mind, we will now deal with other issues posed in the application under consideration.
I will deal with the second issue on whether the DCJ can assign judges pursuant to 165 4 of the Constitution. There is no doubt that this was the most contested issue the subject. Article 165, Subarticle 3 and Subarticle from the Constitution provide for empanelment of benches of an even number of judges as follows. In dealing with the above issue, courts have taken two diametrically opposite positions. One of them being that the assignment of judges is a constitutional duty which can only be undertaken by the Honorable Chief Justice. As such, the Honorable DCJ cannot assign judges under Article 165, Article 4 of the Constitution. The other position posits that although the duty to assign judges is provided for in the Constitution, its implementation is administrative, and that duty can be undertaken by the Honorable. In Kenya Medical Research Institute, so that we the bench of this court held as follows. Paragraph 37. Therefore, by empaneling this bench, the Chief Justice was carrying out his constitutional mandate as opposed to similar functions under the former Constitution, which were changed on the constitutional provisions and were merely added. In Lena, Conchela, and others, it was a right bench of this court. The court went ahead and described the role of the Chief Justice under Article 165.4 as constitutional as opposed to a merely administrative function. It also said it is our view that a constitutional mandate of the CJ can be judicial, administrative, or political, and the current constitution does not indeed state that the Chief Justice is the head of the judiciary which embodies all these functions. The learned judges in that bench and found that the constitutional mandate exercised by the CJ under 165(4) of the Constitution is an administrative function. The court also elaborately dealt with the issue as to whether such an administrative function could be undertaken by the Honorable CJ, and in the end, the court rendered itself as follows. Quote, paragraph 78. It therefore our finding that the constitutional function of the CJ to assign benches under Article 165(4), being an administrative function, can be performed by the Deputy Chief Justice when the Chief Justice is for good reason and unable to perform. The petitioners in this matter also cited the decision in Okoiti versus JSC and another, this constitutional petition number A408 of 2020, as addressing the position that the assignment of judges is a constitutional mandate and the sole preserve of the Honorable Chief Justice. The decision was delivered by yours truly, who is part of this. We have carefully considered the same decision. One of the issues therein, which may be said to have a bearing on this matter, was whether the Honorable CJ would rely on Section 5, subsection 4, and subsection 5 of the Judicial Service Act to authorize the Honorable DCJ to serve as the acting Chief Justice when the Chief Justice was proceeding on leave pending retirement until when a succeeding Chief Justice was appointed. As the matter did not deal with the nitty-gritties of the aspect of assigning of judges, but rather the constitutionality of the actions of the CJ in this matter, including the executive action as well as judicial action. We have gone through that. I do not that from the above, we do not find any difficulty in affirming the position that a constitutional mandate of the Honorable Chief Justice can be judicial, administrative, or political. We further find and hold that the constitutional mandate exercised by the Honorable Chief Justice under Article 165 of the Constitution is a constitutionally administrative function. So now consider whether the function of the Honorable Chief Justice under 165 Article 4 of the Constitution can be performed by the Honorable DC. Article 161 of the Constitution establishes the office of the Chief Justice as the head of the judiciary, and that of the Deputy Chief Justice as the Deputy Head of the judiciary. Article 163 of the Constitution creates the Supreme Court and designates the Honorable Chief Justice as the President of the Court. Deputy Chief Justice is to deputize the Chief Justice and is also the Vice President of the Court. Article 171 of the Constitution establishes the Judicial Service Commission as one of the Chapter 15 commissions. The Honorable Chief Justice in BSc is the chairperson, and in this scenario, and unlike the constitutional architecture in Articles 161 and 163, the Honorable DCJ is not the vice chairperson of JSC. Running alongside the foregoing are the functions of the Chief Justice and the Honorable DCJ as provided for in Section 5 of the Act. The provision states as follows. This is administration of the judiciary. To say that the decision in Lena Conchela also dealt with the definitions and various types of deputies, and ultimately rendered itself in the following manner. This one is paragraph 77 says, it has been canvassed before us that where the Constitution, this chapter does not have a general provision as regards the utilization of the justice by the Deputy Justice as is provided for in Article 161 to provision of the utilization of the justice in chapter number 9, a holistic and purposeful interpretation of Article 161 to B of the Constitution and Section 5 of the Civil Service Act as to the conclusion that the Deputy Chief Justice substitutes the Chief Justice where necessary. And the learned judges found and held that the constitutional function of the Honorable Chief Justice to assign benches under Article 165 of the Constitution, being an administrative function, can be performed by the DCJ when the DCJ is unable to perform this. On our part, we have carefully addressed our minds to the issue. We find that there was a deliberate scheme by the drafters of the Constitution for the Honorable DCJ to deputize the Honorable CJ as Deputy Head of the Judiciary and as the Vice President of the Supreme Court, but not in the JSC. Such was an emphasis on the various manifestations of the constitutional duties bestowed upon the Honorable Chief Justice and the Honorable DCJ. As such, the prevailing legal position is that the Honorable DCJ can deputize the Honorable CJ in discharging judicial function and in the administration of the judiciary as an arm of government, but cannot do so in respect of the affairs of the JSC. Our attention has also been drawn to the provision of Article 259, Article 3B of the Constitution, which says as follows. This refers to construing the Constitution, and Article 3 provides as follows: every provision of this Constitution shall be construed according to the doctrine of interpretation that the law is always speaking, and therefore, among other things, b. any reference in this Constitution to a state or other public office or officer or a person holding such an office includes a reference to the person acting in or otherwise performing the functions of the office at any particular time. Emphasis, or otherwise performing the function of the office at any particular time. The above provision creates three tiers in which constitutional functions can be exercised. That is, by the substantive office holder, or by a person in an acting capacity, or by a person otherwise performing the functions of the office at any particular. In our understanding, and against the background of the doctrine as stated, the drafters of our Constitution were deliberate about ensuring that the administration of duties and the application of the constitutional provisions are continuous and seamless, recognizing the necessity for offices and their functions to perform even in transitional or extraordinary circumstances. Such an interpretation avoids technicalities and vacuums that would disturb the functioning of said offices of public institutions, thereby promoting administrative efficiency and upholding the principles of constitutional governance. The provision reflects the broader principles of the rule of law and good governance, which require that state and public offices continue to function effectively, even during periods of transition or when the substantive office holder is unavailable. It in turn promotes legal certainty and administrative efficiency by ensuring that all constitutional responsibilities are carried out without disruption. For this reason, the functions of Article 165, Article 4, in our view, and in as far as the same relate to the office of the Chief Justice, also includes the Deputy Chief Justice acting in the capacity of the office of the Chief Justice or discharging his function in an interim, acting or auxiliary role. At this point in time, we also wish to point out that the Honorable Chief Justice empaneled this very bench on the 14th day of October 2024 to deal with 6 constitutional petitions that inter alia challenged the first petitioner's impeachment process in the National Assembly. The said petitions are still current. On the 18th of October 2024, the Honorable DCJ empaneled the same bench to deal with constitutional petitions alleging the impeachment of the first petition in the Senate. To us, it is beyond peradventure that the Honorable DCJ can assign judges under Article 165 of the Constitution whenever he or she is discharging any of the constitutional functions on behalf of the Chief Justice. In this case, we do not find any fault in the Honorable DCJ assigning judges to sit in this bench, more so when the Honorable Chief Justice has not raised